afternoon, everyone, and welcome to Legal Aid Queensland's webinar on therapeutic pathways within the criminal courts, Queensland Drug and Alcohol Court and CourtLink. My name is Catherine Gorta and I'm the Community Legal Education and Engagement Coordinator here at Legal Aid, and I welcome you to today's webinar. Apologies for being off screen, but we will have our two presenters on screen today. I'd like to start by acknowledging the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. So thank you for joining us. Again, today's topic for the webinar is therapeutic pathways within the criminal courts, looking at QDAC and CourtLink. We have two presenters with us today. I'd like to welcome Penny Williams, our principal lawyer in our Queensland Drug and Alcohol Court team, with us here today, and Stephen Erickson, also from our Criminal Law Services team. Welcome, Penny and Stephen, and thank you for making time to be here today.
Thank you for having us.
Thank you. I also have, tucked away in the corner here and off camera, Melissa Butler, who is the Operations Manager of CourtLink, and Melissa will be sharing some insights today as needed about the CourtLink program. So thank you so much, Melissa, for being here. A little bit of housekeeping before we get to the content today. So this webinar is being recorded. The laws and content are accurate as of today and are subject to change in the future. You can find out information about our community legal education program and resources on the Legal Aid website. If you have any technical issues, sound issues today, you will need to contact GoToWebinar customer support for that help. Unfortunately, I cannot provide that during the live webinar, but hopefully everything is working okay for all of you. A little bit more housekeeping. We do have a 1 hour webinar today. It'll be approximately 40 to 45 minutes of presentation time with some time for questions in there. On your screen, you'll notice there is a box where you can type some questions, and we encourage you, if you have any questions throughout the webinar, to type them in. If we can get to them during the presentation, we will. Otherwise, we'll hold them over to the Q&A session at the end of the webinar content. A copy of the webinar slides from today are available to download as a handout. That's an option on your screen if you wish to have a copy of those. And we'll also send a copy after the webinar with a link to the recording. And we'll kick off with a poll to find out a little bit more about you who's joining us today. So the first poll is, what region do you work in? And I'll just launch that one. So the options are Southeast Queensland, Far North Queensland, Regional Queensland and outside of Queensland. So I'll give you all a few seconds just to pop your answers in. And so far, Southeast Queensland is definitely the most popular category. A couple more seconds. Okay, I'll close that off and just share the results. So 64% of our attendees are from Southeast Queensland. We've also got about 16% from Far North and Regional Queensland and 4% from outside of Queensland. So good to know that.
Welcome.
Yeah, welcome. Our next poll is, what is your role? So I'll just bring that one up for people to answer. I'll launch that. So the options are support worker, financial counsellor or health education worker, excuse me, social worker, lawyer or other. I'll just give you a few seconds to pop your answers in. Couple more seconds. And I'll share those results. And it looks like today we've got more than half of you are lawyers joining us today, so that's great. We've also got a fair few social workers, support workers and other joining us. So thank you and welcome to all of you. And I'll just go to our last poll. So we'd just like to know, have you referred clients to QDAC or CourtLink before? And the options are yes, frequently, sometimes, rarely, never, or I don't know what these programs are. couple more seconds. I'll close that off and share. So more than a quarter are saying, I don't know what these programs are, so good. You're in the right place to learn more. And another 28% are saying sometimes, 40% frequently, and the balance rarely or never. So glad you're here to learn, glad you're here with us to learn more about these programs. And I'll just run through briefly what we're going to cover today. So we'll be looking at what the QDAC and QDAC programs involve, how therapeutic programs like these can help offenders improve their circumstances, eligibility requirements, referral processes, outcomes for program participants, and how your agency can be involved. And I'll hand over to Penny to cover the QDAC content. Thank you, Penny.
Great, thanks very much, Catherine. Okay, so looking at the Queensland Drug and Alcohol Court, as you can see from that first slide, it's an intensive and targeted treatment and support program for adult offenders where a severe drug and or alcohol use contributed to their crimes. Bless you. It was came into play in 2018, the beginning of 2018. It was a Queensland government initiative following on from a previous drug court initiative, which came in 2000, early 2000s, and was and ceased in 2013. So the Queensland Drug and Alcohol Court came into being beginning of 2018. So it's been going for approximately, what's that, 7 years. And during that time, we've had a number of people referred to the Queensland Drug and Alcohol Court. And obviously, as you can see, one of the first requirements is that a person be an adult offender. So it's a court for adults. Roughly the order is made up of a prison sentence of up to 4 years, which is wholly suspended for at least 2 years. And those of you who are lawyers who practice in criminal law will be aware that if someone received a prison sentence of up to 4 years or 4 years, it would have to be wholly suspended for at least 4 years, because that's the law under the Penalties and Sentences Act. But it's just giving you an idea that the sentence can be up to 4 years, so it could even be 6 months or 9 months or 12 months, which is then wholly suspended for 2 years, at least 2 years. And that's because the program is considered to take most people about 2 years to complete, given that experts have looked at how long intensive rehab should be given to someone to help them on their journey to recovery. Because of course, a court such as this, and even CourtLink, I think Steve will probably agree, they're not a quick fix. They're not, this is going to solve everyone's problems for the rest of their lives. This is something that can hopefully help a person get on the right track, because they've been going off track, because these alcohol and drug issues have contributed to criminal offending. It involves, the Drug and Alcohol Court order involves the completion of a 3-phase treatment program. Now that was similar to the last drug court that was in Queensland. So it's 3 phases, with the first phase being really intensive and requiring a lot of close contact with the teams in drug court and the court. And then as a person progresses and shows compliance and development of their skills, they move through phase 2 and phase 3, which obviously lessens the period of intensity and lessens their requirements, because hopefully by the end of it, the order, a person is then fully, reintegrated back into the community. As you can see there under point 2, during that 3 phases, there's regular court appearances, random drug and alcohol testing, and that's in phase 1, at least 3 random drug and alcohol tests a week. That means minimum 3, so it can be up to 6 or 7, and there is weekend drug and alcohol testing also that is random. Housing assistance and other supports can be offered to people who require it. Legal representation, which is again part of our role, and that's not just for criminal matters, but we might be able to assist to direct people to get other assistance, such as areas of family law, which is a big one, and even civil matters that may come up, or perhaps residential tenancy issues, and their close engagement with the magistrate. The other thing is, which I'll come to it a slide later on, is the court has a rewards and sanctions framework. It's called a behaviour consequences framework, and it's a way that the court when they're looking at a person's compliance can either help to encourage more engagement and reward those people who are engaging well. And they're not tangible rewards, but they're rewards such as perhaps moving through the program a bit quicker. The aim of the program, as you can see at the bottom there, is to reduce an offender's substance use disorder and decrease their risk of reoffending. The legislation that's applicable for the Drug and Alcohol Court can be found in the Penalties and Sentences Act, section 151, and I think you'll note it just goes all the way through from 151, and there's A, B, ZA. You'll see all that in the legislation if you're interested in looking at that. So this slide, even though you might think perhaps I should put this at the end because it's kind of showing what can happen or the outcomes for people who engage in drug court, I just thought I'd preface, I guess, the discussion about the court to sort of show you all how engaging in QDAC, and that's the abbreviation for the Queensland Drug and Alcohol Court. So if you hear me say QDAC or others, it's simply to stop having to say the full name. Engagement in QDAC, we've seen so far from the people who've graduated or even people who've completed. So even people who just complete the 2 years but perhaps didn't get all the way through to phase 3 and then on to graduate, engagement in QDAC can still help to improve family relationships, increase pro-social support networks, engage in work and training, upskilling. You can see also there's been aims and also we've seen outcomes where people's mental health stability is improved, their medical treatment. We work closely with other departments because the Drug and Alcohol Court involves other government departments, and that's namely Queensland Health, Corrections, Queensland Police and our office Legal Aid Queensland, with the Department of Courts and the Department of Justice to assist people to improve their lives. And so we can also have a close relationship if a client or a participant wants us to assist with any Department of Child Safety matters. And that can include even giving them the outcomes of their drug testing, and that can certainly assist them. And again, what I just mentioned before about our role at Legal Aid, we're not only there for their criminal law matters and to help them with the order, but also direct them to perhaps some family law assistance through Legal Aid. And then lastly, of course, there's a number of people that can have some previous or past trauma, and it may be that they need some assistance with issues like that, and we can assist in that area too. And when I say we, I mean the global, all those agencies together, obviously working together to help someone. So just turning to the eligibility requirements. So if you're now thinking, well, this order does sound like something that I have some clients in mind for, or just, you know, okay, this sounds really good. How do we get involved in this government initiative? To be the basic eligibility requirements, the offender must be an adult, facing criminal charges that can be addressed by magistrates court. So even though there are indictable offences that can be sent to the district court or Supreme Court, if those matters can be addressed by a magistrates court and it's perhaps the defendant's election, then they can be dealt with in the Drug and Alcohol Court, because the Drug and Alcohol Court sits within the Magistrates Court jurisdiction in Brisbane. The person must be intending to plead guilty. Now this is because this court, the Drug and Alcohol Court, is a sentencing court. It's not a court for summary trials, and therefore the majority of case conferencing needs to be done before the person comes to drug court, if it can be attended to. Obviously, this can be minor matters such as alternate charges or the such like, which can be dealt with by the QPS team in drug court. The person must be living or intending to live in the Brisbane Magistrates Court district. There's been a little bit of flexibility about that given the housing crisis lately, and that can be addressed through really the magistrate inquiring about the availability of public transport, the means to be able to move in perhaps closer at some point. Those are sorts of things which at this stage, if some of you are thinking, well, I've got this great client, but they're at Ipswich, it's something that maybe that person could phone me or my team and we can discuss it a bit more about the transport routes into the city and whether this is really a viable option or not. Also, suffering from a severe substance use disorder. Now that sounds a bit wordy, and perhaps certainly for lawyers we're probably thinking, well, how are we going to know that? Really, if your client, the bottom line is if your client is saying to you, look, drugs or alcohol contributed to my offending, that's all you need to really get from your client. Because once that person is referred to drug court, the very first court date in drug court, we have a Queensland health clinician who speaks to them and assesses the person's severe substance use disorder, which is using the DSM-4.
Penny, I have a few clients that are in custody that I think would do well on the drug court program. Would they be eligible for QDAC? Yeah,
good question, Steve. Thanks. Yeah, so that's one thing I wanted to mention was a client can be in custody or on bail. So anywhere in Queensland in custody, in fact, because often we know, even Steve, you'll know from our clients, that they're not all at Arthur Gorrie Correctional Centre or Brisbane Correctional Centre. They might have been through no choice of their own sent to Capricornia or perhaps Townsville, and they would like to access this program. So if they have an intention to live in the Brisbane Magistrates Court District, they can still be referred, and we have had people from other custodial centres be referred and sent from that custodial centre to a closer centre here and go through the process. And that really leads me, I guess, to talking about just the final eligibility requirements before looking at the process. And I'll get to the next step of the process in a moment, which will impact perhaps some of those people who are coming from further afar. So participants, one of the things about what they can't be, so we just talked about what they should have. A person can't be referred to drug court if they're on parole, so currently on a parole order, or serving a prison sentence, and that includes perhaps they've been put back in custody for a return to prison warrant, as some of you might be aware of that term. They also can't be charged with a sexual assault offence. Now, that doesn't necessarily mean on their history. So charge means there's a pending charge before the court, which fits the category of a sexual assault offence. If the charges perhaps breach a parole order, because we have had a number of clients come for their eligibility where they have charges which would breach a parole order that that person used to have, but now they're in custody purely on remand because that parole order is finished, those clients can still be referred to the drug and alcohol court. Because again, as a lot of the criminal lawyers perhaps who are listening in would know, if they're given a suspended sentence, which the drug court is a form or a condition of a suspended sentence, it's that custodial part I referred to earlier, then they aren't in that position where the court would have to impose a parole eligibility date. So if they've got those charges, how it's seen, I guess, by the drug and alcohol court is that's actually perhaps for some people an added motivation to want to do this program and to want to be successful, because if they don't succeed and they face a revocation sentence, then again, as a lot of you would know, it's open to the court to activate imprisonment on that suspended sentence. And if those charges did breach a parole order, that person would face a parole eligibility. So it can be an added incentive for a number of the clients that really, they've hit their bottom line and really now this is the only way is up and they need to be more purposeful with what they want to do moving forward. You can see on that slide there at the very bottom, that website. I really encourage you all to take note of that website. The Queensland Courts and Department of Justice have done a lot of work to put a lot of resources on that page. You can see it's an easy drop down in the Queensland Courts website. When you go to those tabs at the top and it says courts, it drops down a list and you'll see drug and alcohol court is on there. And if you click on that, there are a number of resources. There's the referral form that I'm about to refer to next. That you need to actually get the referral from Magistrates Court to the drug court. And there's a number of fact sheets that are on there that are written in really plain English that can help your clients, families of your clients, yourselves, or just really other resources that can be really helpful. So please, I encourage you to, if you've got some time, just to jump on there and just have a look at what's on that page. So turning to the referral process, you can see there on the screen, that's actually the front page of the 3-page document that is called the referral form 1. Now, really, that page there that you see is the only page that you have to complete if you're the referrer. So I've mentioned 3 pages, but do not stress, it is simply just that page. And really, you can see at the top of that page, the first half is just the defendant's details and your details as the legal rep or the person who is referring. So it's just some basic details to give the drug court team an idea of the person's, whether they're on bail, whether they're in custody, if there's any accessibility issues. And then you'll see on the second half it refers to an eligibility screening checklist. And there are 7 points there that just are the real basics that are required for, as I've mentioned, that eligibility. And you'll see there are things there that I've just covered already. Now, referrals, you can see, can be made by a number of people, but you'll notice the very last dot point in that screening checklist on the Form 1 on that first page is that the person being referred has agreed to be referred to the court. So we have had some people who are very well-meaning from a support agency or even a participant's family who want to see their loved one or the person they're helping be referred to this court, but ultimately it is obviously the defendant's decision and has to be something that they are agreeable to, because when that person then is referred to drug court and they meet me or my team or other members of the drug court, the first question will be, do you know what drug court's about, and are you wanting to do this? And we don't want them to be saying, no, someone referred me and it wasn't my decision at all. So this form is the form that would be tendered or given to the court when the person has their mention in the magistrate's court. And then it's because the second and third page is what the magistrate looks at and signs off on when the referral is made. And that form can be found on the website that we just talked about. Now, just to briefly cover, because perhaps it's a bit of a wordy slide, the pre-sentence assessment process. And the reason I've put this in is because I get a number of queries, and I'm more than happy, and so are my team, from lawyers and even support agencies asking, well, what happens after we've referred a person to drug court? Because we kind of don't know what happens in the specialist court. It's all a bit of a hidden or a bit of a mystery. So this is just really to give you an idea of the work that is done once a matter is referred to the drug court. So you can see that cases, once that eligibility is confirmed, and I mentioned earlier about Queensland Health doing that screening assessment when a person first comes to drug court. So that screening process is done, and if they are ticked off as eligible, their matters then adjourned for 5 or 6 weeks for a suitability report. And you'll see on that first line, it really deals with every agency that's besides legal aid, so that's corrections, health and the police, looking at risk factors, but also what factors and what background and circumstances the person presents with, and would they be a good fit, and would there be a treatment program available for this person. You'll see then the graph or the process then talks about the report being provided to the lawyer and the magistrate, and then there's a suitability discussion with all agencies discussing it, and then if the person's found suitable, the sentence is listed. And there are 2 types of programs, so I'll just flip to the next slide. There are 2 types of programs that QDAC offers at this stage, which is residential rehab and outpatients. Residential rehab can be at a number of different rehabs that have taken clients who are doing QDAC. And for example, we have residential rehabs as far as Sunshine Coast, being Hoosnajara, there's Murnia, Fairhaven, and some of you will know Fairhaven is down on the Gold Coast, and Logan House, which is at Chambers Flat. So they're spread different areas. And if a participant is referred to a treatment residential rehab as part of their treatment program, that person is able to stay in that program and participate in that program for as long as that program needs them to do that to be completed. And the court will only have contact with them by phone during that period of time. So it's really enabling that person to get the most out of the residential rehab and not require them to have to keep coming into Brisbane to court to speak to the magistrate. So it's really about encouraging and helping them to stay and remain there and keep working at it with the regular contact from the magistrate. But for everybody else, there is the outpatients program. And you can just see there, I've just put in some brief overview of the sorts of things that you would be subject to, or your clients would be subject to, should they be part of the outpatient program. And you can see from that, maybe to you and I, it might not look like too much, but for obviously the majority of the clients who come through the drug court, for a lot of them, they've never had a routine before in their lives, or their routine has simply been to wake up at about midday and then obviously use drugs or alcohol, then perhaps go and have to find a way to get more drugs and alcohol, and then stay up really late at night. So they really haven't had this routine that you and I would perhaps be used to of getting up at a set time, being at a set place, meeting appointments. And so whilst again this doesn't perhaps look like much, it really is really is the basic requirements which are then built upon depending what a person's further needs are. So these are the mandatory requirements. The next slide also shows though that the program could include, and as you can see then there's further sessions. So once a person starts to engage with Queensland Health and with corrections, and those two agencies are what we call the treating teams within drug court. They're the predominant teams that obviously impose the treatment or the monitoring or supervision and assistance, even though obviously Queensland Police and Legal Aid are still considered part of the treatment team. So the program could include education sessions, and both corrections and health, we're very lucky that both of those agencies provide excellent programs, such as the Making Changes program from corrections, and also the early relapse support program from Queensland Health, which are usually around anywhere between 12 to 18-week programs. And a lot of participants, I have to say, in my experience, and I've been with the drug court since it started in 2018, most clients at the very beginning think, oh no, this is going to be awful, it's going to be like going back to school. But really, the majority, once they've been about 3 or 4 times, they really appreciate and understand the importance of the education that will help them to be able to deal with the issues they have, and it gives them insight into perhaps why they've been feeling the way they've been feeling, or to deal with anxiety, or just ways of dealing with triggers when something happens, like someone passes away, how to deal with that more appropriately. Which is awesome for me to see that they can get the most out of those sessions that way. Also, they could be getting an external psychologist, so that's another thing that can often be given, particularly if there's a redress issue. I mentioned earlier about this behavioural consequences framework, so I just briefly added this in. Now I know this is probably going to be, and I could spend about 30 minutes trying to explain it because it can be quite tricky even for our participants, but even for staff who are coming into drug court. The behavioural consequences framework essentially is just a framework where points or days, they call them days, but the clients learn them as points because it's basically 1 to 13, that accrue if you don't do things that you're supposed to. So if you don't go to a drug test, or you don't go to your case management, you can get points allocated for that. And if you accumulate basically 13, you can risk being put in custody by the magistrate for 7 days. So the framework is there that once a person starts accumulating these points, we all, as different agencies but supporting the same person, try to encourage that person and work out what's the barriers, what's the behaviours that's causing the issue, and try to help them to undo that so that they actually get points deducted because they're meeting goals and they're doing positive activities. So it really is meant to be not a punishment system, but simply a way of being able to encourage particularly those people who are falling short, or maybe just having one bad week, and helping them to realise that that doesn't have to bring them undone completely. Just wanted to finish off by just confirming what really our involvement is in drug court, and you can see there that some might say, well, corrections and health, I can understand that they're the sort of teams that supervise and monitor and help people with their health and moving on in order to progress. But how does legal aid get involved? So really our involvement is quite unique because we're there obviously having helped the client be sentenced to an order through that pre-sentencing process, but then from then on, we're there really to ensure procedural fairness at all times, because it is a court. It is a drug and alcohol, and that C stands for court, so it's a court environment. To help those participants adapt to their new routines, to explain the behaviour framework, and really, as I mentioned earlier, provide information to family members and others, and also yourselves if you need that information. So in summary, I just wanted to really focus on the phone number, and I know that's an extremely long email address, but mainly the phone number. My team, the Drug and Alcohol Court team at Legal Aid, has a mobile number which is on 24/7, but obviously we won't necessarily answer it 24/7, available for participants, their families, and also yourselves. If you have a question, if you're in court with a client and you think they might be good for drug court, please feel free to ring, feel free to email that email. Also, you know my name is Penny Williams. At Legal Aid, it's our first name dot last name. If it's easier just for you to email me, even more than happy to receive any queries. No question is too silly or simple, because that's my role and my team's role is we're there all the time. We get to know what happens, and we get to know the magistrate's views on would this be someone who's eligible? What about if the client has this charge on their history? Those sorts of little nitty-gritties that you may not necessarily know, and we're more than happy to chat to anyone about these matters, particularly about drug court in general.
Thank you, Penny. Thank you for covering off on QDAC. I'm going to hand over to Stephen now to run through CourtLink.
All right, so again, thanks for joining us. What we've got on the first slide is a YouTube clip to a short video that was created by Legal Aid Queensland, Police Prosecutions and the Department of Justice and the Attorney General in collaboration with the Queensland Sentencing Advisory Council. I won't play that video at the moment, but that link will be available with the slides that are sent out. That just provides a really detailed but short overview of what the role is of the different participants within the CourtLink program. So I would recommend to go to that link, have a look and have a watch, because it is very interesting and informative. So what is CourtLink? So CourtLink is a voluntary bail-based program designed to help defendants with a range of issues that can lead to offending. Despite it being a bail-based program, clients in custody can participate through the triage assessment. So although you don't need to currently be on bail when you're assessed, it can be an assessment which is used prior to an application for bail, and that can assist the court to see that there will be some wraparound support should someone be released on bail and admitted onto the CourtLink program. So step one is the CourtLink officers can provide case management for 12 weeks. We'll get into what that involves shortly. People identified as having moderate to high risks of reoffending and needs are more likely to be suitable for the 12-week program. Those that present with low to moderate risks are still provided assistance, and that's through the form of community-based referrals which can be made. Once someone is deemed suitable, through a triage assessment, a case plan is developed. So the key issues are identified where CourtLink can provide assistance for need and support, and refer the defendant to treatment and support services for brief interventions.
Steve, can I ask you a question? Some people have asked me, and I'm just curious, do you have to be looking at pleading guilty to access the CourtLink program? So does it have to be just people who are intending on pleading guilty? No, so unlike drug court, it's not a sentencing court. So you don't have to enter a plea of guilty to be participating through the CourtLink program. There are participants that can still proceed to a summary trial. The benefit of CourtLink is to get the individual back on their feet from the issues that they're struggling with. A plea does not need to be indicated, which is a very important feature. So thank you for asking that, Penny. So with the CourtLink 12-week program, phase one, which I'll refer to it as, is the assessment phase. So a CourtLink case manager will sit down with the participant and identify the level of support needed. So questions will be asked and those areas will be identified. As mentioned earlier, if there's a lower risk of reoffending, there can be community-based referrals made to try and link in with services within the community to address those needs. The aim, of course, is to avoid service delivery duplication. So in the assessment phase, if a participant or an individual is currently subject to a rigorous probation or parole order, it may be the case that there'll be a duplication in services that that participant is already engaging with, and that's when it may be the case that they're not deemed suitable for case management. Participants must be able to attend CourtLink appointments on a weekly basis with their case manager, and the court will be the deciding factor as to whether the participant will be admitted to the program. So CourtLink will perform a triage assessment. The individual will be afforded the benefit of engaging with a duty lawyer or their solicitor, and then in the first court appearance before CourtLink, it'll be the magistrate that will review the triage assessment, speak to any further parties if required, then make a decision if someone's admitted onto the 12-week program. So being a 12-week court-based program, there are
are progress mentions throughout the proceedings. So the progress is often overseen by the magistrate every 2 to 4 weeks. That depends on the level of participation and engagement of the individual. The progress reports are written by the court link case manager, and they are provided to the participant, the defence solicitor, the prosecutor, and also the magistrate. Reports are strength-based and therapeutic, but also honest with the progress that's been made by the participant. It is a very therapeutic court environment, and the magistrate provides encouragement to each individual at the time of the mention. The magistrate may touch upon the positives and or negatives that are referenced within the report that's been provided. As a lawyer that's represented many clients through CourtLink, I've found that the encouraging words from the magistrate directly to them has been a large motivating factor in them participating further, wanting to build upon their confidence and do better. So that's been a very helpful area of CourtLink. So further charges. So it's often seen that people appearing before CourtLink may have some minor charges that are accrued during the 12-week program. If the person is charged with further offending, those charges can be adjourned to join up with the other matters that are presently before the court. And what's referenced in the slide as well is there is no limit to the number of times a person can do the CourtLink program. So that means that if someone participated successfully through the 12-week program, they've been sentenced or they proceed to a summary trial for their charges, they can return in 6 months' time or 12 months' time if they are charged with further offences and re-engage with the CourtLink process. Furthermore, someone may have participated briefly with the CourtLink program. They could be exited due to non-engagement. They can, when they're spoken to again by their solicitor or another referring party, be re-referred to CourtLink for another triage assessment. So just because someone has not been successful on the CourtLink program initially, they can be reassessed and readmitted. Often what would be looked at is any change in motivation or attitude of the participant, but I've certainly had several clients that due to personal issues that have been going on at the time were unable to successfully complete the initial 12-week program, but have been re-referred 1 or 2 months after their exit and have been readmitted onto the program and have completed it successfully. So again, if you have a client or someone you're working with as a support worker that have informed you that they enjoyed CourtLink or they want to participate on CourtLink but have been previously told they can't do it or have been exited, my advice is to refer them for a triage assessment and allow that assessment to take place to see if they would be suitable.
And perhaps if I can mention here, that's where drug court and CourtLink work really well. In that certainly if someone's referred to drug court and perhaps we think really that we might be over-servicing them, we can look at would they be interested in the CourtLink program and vice versa, where there might be some further offences that maybe put them in the realm of imprisonment, getting more and more certain that CourtLink can refer to the drug court.
That's right.
Yeah.
Both work hand in hand in determining the individual's needs, and depending on what those needs will be, there's certainly several options available for therapeutic models before the court.
And helpful that they both work out of level 4 of the Brisbane Magistrates Court building. So the same reception, multi-pronged approach.
In terms of the eligibility for CourtLink, it's only available for adults, so children proceeding before the court cannot be referred to CourtLink. As mentioned earlier, it is a bail-based program, so they either have to be on bail or applying for bail. If someone is remanded in custody, they're not eligible, but they can participate in a triage assessment if an application for bail is going to be made. They have to be charged with a criminal offence and appearing before one of the CourtLink locations. So there are 11 locations which are on the slide there. There will be a further 2 locations which have not yet been determined for 2025 or 2026, but it is an expanding model and hopefully we'll be able to reach out to further areas of the Queensland community. The defendants often will need to identify and present with areas that need assistance or support. That's often seen for drug or alcohol use, physical or mental health issues, impaired decision-making capacity, or homelessness or risk of homelessness. So the referrals are made through the Form 1 referral form, which I have on screen. There's a link attached to that. And again, the slides will be provided. So please utilise that link as a quick way to reference that. Referrals can be made by the individual's family, police, lawyers, and magistrates. So it's a very broad scope in terms of who can make those referrals. As Penny had mentioned with the drug court referral form. Again, it's very straightforward, very simple. Majority of that form just relates to the individual's details and then addressing the areas of need, as well as making a reference to whether the participant is aware that that referral has been made. So in terms of legal aid's role with CourtLink, we provide duty lawyer services in most of the court locations where CourtLink is operated. If not a duty lawyer service, then we can provide representation from start to finish where a grant of aid has been issued. And of course, grants of aid are merit tested and means tested. In terms of what the duty lawyer service would look like on the day, that commences with meeting the client before court. We're often provided the assessment or progress report from the case manager. We provide assistance and advice to the participant. We appear in court for the client on the day. We provide them advice and guide them through the phases of the 12-week program, identifying which stage they're presently at. We go through the progress report or the final report with the participant, and we appear at sentence if the participant is pleading guilty. If the participant is not pleading guilty and is endeavouring to proceed through a trial or case conferencing, we will provide them advice on what steps they need to take and make sure that the matters are adjourned to the appropriate court for that to take place. So potential outcomes of CourtLink. So very similar to some that Penny had mentioned, but CourtLink, again, canvasses other areas. So the potential outcomes are engagement with treatment and support providers, and that can continue past the 12-week program. The quality of life. So people often feel better and have a clearer path moving forward once they've completed the program. Mental health treatment plans are in place, and we will discuss some success stories with respect to those shortly. Housing options are explored and are on the path to getting housing. Getting access to the NDIS program, obtaining identification documents, so they're known barriers to making positive changes such as birth certificates and IDs. Handovers to the Department of Community Corrections where a probation or parole order is made at sentence. So that allows for the probation officer or parole officer to have a greater understanding of the individual. It means that when they undertake their initial assessment with probation and parole, their officer that'll be involved has a very clear understanding of the work in progress that's been made, and they'll be in a better position to ensure that that progress continues. Completion of the 12-week program may be considered at sentence, so there's often a reduction in penalty which is seen. The court can consider the defendant's rehabilitation within the sentencing provisions of the Penalties and Sentences Act. So touching upon those last 2 points there, when a person's being sentenced, if they've successfully completed the 12-week program, the court will take into account that there's perhaps less need for specific deterrence when imposing the penalty. That's because the court are able to see the significant strides that a participant has obtained while going through the 12-week program. What that often means is the penalty can be reduced for someone that would otherwise have needed a probation order to ensure they're engaging in services. The court can see that they've already successfully undertaken that for a period of 3 months. That can often lead in potentially fines being imposed instead of a probation order, or a probation order for a shorter duration of time. There's often persons that are on the cusp of an actual period of imprisonment for their offending. That's because due to whether it's mental health, substance abuse, or lack of accommodation, that's directly linked to their offending. After successfully completing the 12-week program, often participants have commenced some drug courses through Drug Arm, may have some short-term accommodation, and they've specifically addressed those areas that gave rise to the offending. The court may be more reluctant to impose an actual period of imprisonment because the individual or participant has made large strides in getting themselves back on track, and an actual period of imprisonment can be seen as something which would deter their progress moving forward. So it can often result in a suspended term of imprisonment being imposed. So the benefits for the individual are twofold. One being, of course, that they're able to address these significant issues that are presently going on with their lives, but also the benefit in terms of the outcome with court when the matter's resolved. I do have some positive outcomes from the engagement, and with one of the initial slides, I did touch upon some of the 4 key areas being participants with lack of accommodation, financial issues, substance abuse issues, and mental health. So I'll touch upon very briefly some successful outcomes for all those with accommodation support. So for client A, he had been homeless for over 2 years. He'd been sleeping rough. QDAC provided basic bedding items using brokerage and worked closely with local support services to get him into emergency accommodation. He was also supported through the process of applying for social housing, something he'd previously found too overwhelming to do on his own. So that had set him up after that 12 weeks to be in a much better position than when he prior to commencing the program. Client B, he was young, he was moving between friends' houses, essentially couch surfing. He was assisted to get vital documents like his identification and birth certificate, which was often barriers for being able to obtain support and making applications for either temporary or long-term housing. He was then supported by QDAC to complete and lodge a housing application with the Department of Housing. With the next slide, financial support. So client C was struggling financially. He had a disability that affected his capacity to work. QDAC supported him with making an application for the disability support pension, as well as assisting him to gather medical documents to engage with Centrelink. It also assisted to link him with emergency employment opportunities to explore realistic income options for him. For client D, he had significant unpaid fines as well as limited income. He expressed an interest in setting up a work development order to reduce his spur debt. QDAC were able to assist him to understand his options for exploring his Centrelink entitlements and improving his financial position. For the area of substance abuse, there's been a lot of work done in this space with referral services. For client E, he had a long history of methamphetamine use. He wanted to enter a residential rehabilitation centre. QDAC were able to support him through the intake process, as well as using brokerage to pay for his admission fee. Although there were some setbacks early on, he was readmitted and he later went on to complete the structured program, which made large strides towards his recovery. Client F, she had already commenced engagement on an 18-week residential rehabilitation program, which she'd entered prior to QDAC. During her engagement, she was able to successfully complete that program and the phases through the support that QDAC was able to provide her. With respect to the area of mental health, client G had a long-standing diagnosis of schizophrenia, presently under a treatment authority, receiving regular depot injections. QDAC was able to work alongside his mental health team to ensure continuity of care, as well as monitoring his engagement with community health services, helping him to manage his day-to-day stability to stay out of crisis. Client H disclosed trauma-related symptoms, including PTSD, insomnia, low mood. He had no regular GP or mental health care plan. QDAC assisted him to access a bulk billing doctor, helped him to obtain a mental health care plan, and allowed him to start accessing therapy through Medicare funded services. And client I had experienced a very traumatic year, was eager to access some counselling. She'd previously disengaged from services and hadn't been engaged for a lengthy time. QDAC explored suitable referral pathways and helped her begin reconnecting with mental health support. Small steps in that space were a significant shift for her. So that just covers a brief overview of those areas. If there's any questions with respect to QDAC, as Penny mentioned, I'm more than happy to receive any questions, and I'll ask that my email address be sent out for any solicitors or support workers that may have a question from a legal perspective in terms of referrals or benefits of the QDAC program. QDAC themselves are also more than happy to provide presentations to stakeholders, so any support workers or solicitors out there that may think there's a benefit for their organisation to receive a presentation, please utilise the QDAC details, or we might also provide Melissa Butler's contact information. So that would be very beneficial, just to make sure that all support services and legal practices have a better understanding and knowledge of how these programs operate in the space.
And I think that makes a really good, Steve just probably linked it to a really good point, which is that the government here is offering these opportunities through these two different courts to assist people, particularly with QDAC looking at perhaps the lower end of the range in terms of the person's perhaps potential penalty if they are heading towards the guilty plea, whereas the drug and alcohol court is looking at people who really are looking at imprisonment and offering this program as an option alternative to imprisonment. And so it is an alternative sentencing option because you're facing, like I say, a 2-year order. So it is quite an intensive program to engage with, and it requires people to have quite a big commitment. But often when you're looking at that 2 to 4 years imprisonment, that can be a big motivator.
Yeah. So I think both options are probably a good idea to explore with your client, see if they fit within the eligibility criteria and whether you think that have gained some significant assistance through the programs.
Definitely.
All right, well, that is the end of the content part of our presentation. We now have time to take questions. If anyone joining us today has any questions for Stephen or Penny, please type them, send them through now, and we'll raise those here. We don't have any questions waiting at the moment, so while we give people a little bit of time to type away, I'll just run through the next couple of slides and I can go back to the questions section. So I've just got up on screen here the Legal Aid Queensland contact details. So the first phone number there, the 1300 65 1188 phone number, is our legal information and referral phone line. So that's the key phone number for people to call if they're seeking legal assistance from Legal Help, from Legal Aid Queensland. The next phone number there is our Aboriginal and Torres Strait Islander information line. And now this is a priority phone line. We answer these phone calls as a priority, and that's the 1300 65 0143 phone number. So if you have a First Nations client, please encourage them to use that phone line. The last phone line listed there is for people who do have an application for aid that they've submitted and they're seeking a progress update on that. So that's the 1300 383 900 phone line. Just to mention here that there is heaps of free legal information publications and resources available on our website on a whole range of common legal issues. We encourage you to get on there, print, download and order them. They're available for free with free delivery. So if you want to stock any of those at your organisation, please do take advantage of that and get on there and download or order the ones that you need. It's all free. We run these community legal educations webinars monthly. The topic for our next webinar is changes to the Family Law Act that were recently passed. So that's being held next Thursday, the 24th of July. We'll send the registration link for that webinar out when we send a copy of the slides, but it's also available on our website if you search for webinars. The webinar that you're currently watching will be captioned and it will be published on our YouTube channel, along with all our other webinar recordings from previous webinars we've run. So you're welcome to go and have a look at those. And we encourage you to follow us on our social media channels, which is where we promote our upcoming webinar program. So Facebook, LinkedIn and Instagram are our main channels there. We don't have any questions that have come through yet, so I'll just give everyone a few more seconds to pop a question in the question box, but if you don't have any, that's totally fine. It sounds like we've answered everyone's questions today.
Hopefully.
Melissa from Courtlink, is there anything else you wanted to add before we wrap up for the day?
No, I'm just really pleased to see that there's so much interest in both the programs and really encourage people to reach out if they need any follow-up.
Okay. Well, on that basis, with no questions coming through, I'd like to thank everyone for joining us today. And I'd like to thank Penny and Stephen and Melissa for making themselves available to present this information to our audience. It's so valuable. I hope you can all join us for the next webinar, and we'll log off now and hopefully see you again for the next one. Thanks very much.
Thanks
Bye.
for joining.
Thanks.